so, Dr. G.K. Goswami IPS. As you know, we are discussing various topics with you on law, forensic science, and various other domains which are very critical and important for your purpose. Whether you are a professional advocate, you may be a judge, you may be a technocrat, you may be a forensic expert, and many more such areas. This discussion always help you. That is what you always communicate to me. And this time it is slightly late. This is 17th series, and I am happy that your love and affection always motivate me to ponder different topics. So friends, you are well aware that data protection is the most important area in the modern era. Nowadays, data is the gold mine. Data is the best friend, but everybody is looking for the data. So we have to be very careful. And recently, in 2024, India has developed data protection rules, 2024. A year back to that, DPDP Act 2023 was enacted, and now it is implemented. So there are various other countries like US, UK, Germany, other European country, where data protection laws are already there. So we will have a discussion today on various nuances of data protection, how right to privacy is attached with data, and how legally that should be protected. So let us come together for learning better. So this is the topic, data protection regime, India and beyond. I mean to say that we are going to discuss not only Indian regime, but various other countries like US, UK, other European countries, and so on and so forth. So data protection regime, India and beyond, Digital Personal Data Protection Act 2023 and Rule 2024, we will be discussing in great detail. So probably you are going to benefit it. In next 1 hour, my job is to make you well aware about the latest legal regime in India and abroad. So if we see about the data, this is the modern era of speed. Everything is gauged by speed, and internet and other IT communication, they have made our life very fast. Data is basically new oil. It is very, very costly. It is diamond, and we should protect it. In the age of digital revolution, data management is very critical. Everybody is worried. You might be aware that a lot of criminals from the road, from the real world, they are shifting for committing crime in the digital world. That is why you are looking for, you are aware about digital arrest, sextortion. Last week we have discussed sextortion in detail with you. Cyber frauds, phishing, vishing, and many more such crime. So, data is a revolution. And wherever there are important and valuable, there are chances of its theft, of its attached with the crime. So you have to be very, very cautious and careful. Now, how to maintain the accuracy in data? Because there are so many criminals, they also mixed up, or they also vouch, or sometimes they conceal data. They conceal identity. So data has various facets we will be discussing in terms of how to protect them. Data is also very important in the modern era for innovations. Research and development. You must have heard about AI, artificial intelligence. That is basically the core for innovations in various domains, whether it is space science, whether it is medical science, whether it is physics, chemistry, history, geography. You take nowadays, AI is almost entering into every sphere of life. It is directly hitting economy both ways, in very good manner because technology advance development, and so is with the economies. But on the flip side, the data, if it is stolen, suppose you are a bank, you are a scientist, or you are doing in whatever manner, every information is stored in data format, hence your data is highly vulnerable. There are critical informations which the perpetrators are looking for to steal, so you have to be careful. Data is also very important in decision making. Nowadays, you must be aware about predictions. Like say for example, I am a police officer, predictive science. Now with the data, you can predict the possibility that where the hot spots for crime may be there. Likewise, for healthcare also. So prediction in various domains by way of analyzing and, scientifically deriving inferences, you can make decision in much better manner. Then it helps in governance in various ways. Every office is e-office now, right? Every detail is kept in soft copies in data format. The speed of data transfer is very high. Earlier, files were moving. One paper was shifting desk from one place to another, taking time. Now, just one click, you can send the information. So, governance becomes very important, especially in the era of communication, transformation, right? So, the impact of this digital age is everywhere. Whether it is an individual, it may be an organization, it may be a government sector, it may be a business premises. Another issue here is it is boundaryless. Earlier in the real world, there are boundaries. It may be your house, it may be your city, village, district, state, country, so and so forth. But in digital world, there is no boundary. So we have to think crime also beyond boundaries. Earlier there was jurisdiction. Whenever you see any enactment or any act, there are certain geographical jurisdictions that this act is applicable to this particular area or this particular country. But now in the era of digital communication, the crime, the flow of communication is boundaryless. There is no limit. You can send information in just one click. You can have telephone, you can send emails, any other message just by 1 microseconds. So, in this background, cyber security issues are very, very critical and challenging. There are reported breaches for cyber space. There are unauthorized access. Nowadays, this is the time of deep fake. Your voice, your photograph, your every activity can be cloned. Even your voice cannot be identified even by you yourself. Your signature, everything can be cloned. There are malwares, they steal your data, identity theft, deepfake, and so on and so forth. So we have to critically plan for legal regime. We have to make proper procedures, proper policies, and the policies, laws, and rules, they should not only be made, they should be implemented. So the procedural laws are equally important as are the substantive laws of cyber security. So, the major problem with this legal regime is lack of uniformity. Every country has its own ethos of law. But crime may happen, person may be sitting, whether victim or perpetrator, in India, and he may be committing or getting victimized in Nigeria or any part of the world, right? So, we have to see the law in a very, very different manner. If we have a bird's eye view on the system, what kind of data protection laws are there? So, if we see in India, we have unified law because India has federal system and state also, but our most of the laws are generally like IPC, CRPC, they are federal in nature. They are actually for the entire country. Say for example, earlier it was IPC, or say for example POCSO, or any other substantive criminal law, they are across the country. Earlier, of course, Jammu and Kashmir, the laws were different, but now Jammu and Kashmir is no more state, and hence every law is almost equally implemented. Of course, some state laws must be there. However, if we see about US has two sets of digital laws, data protection laws. One is federal and another are state-wise. That is why it is called sectorial legal regime for data protection in US. Now, friends, let us have a look on global challenges for data security. In a very brief manner, I want to make you understand that what are the challenges before we enter into the real world of data protection laws across globe. First of all, the evolving threat in digital space. Every day, new methods for committing cyber crimes are being evolved. The criminals are equally sharp. They are technologically savvy. They are well educated. So now the crime on road or crime on physical manner, beating, murder, looting, robbery, they are in the downside. Now the cyber crime is on very high rate. I will tell you subsequently that country like UK or the advanced country, the growth rate of cyber crime which are being reported, the growth is more than 100%. So this is the biggest challenge. In India, if you see in last 4 or 5 years, we have more than 45% of reported cases. The growth rate is that much. And as a police officer, I do believe that many of the digital crime, sometimes the victim may not even realize that he or she get victimized, and so is the case for reporting. And unfortunately, the conviction rate is also very, very dismal. Then the problem is with the AI-powered social engineering. They are basically, as I said, the social engineering cyber attacks may include digital arrest, convincing romance, as I told you, sextortion in the last discussion. Then investment frauds, they allure you, they get you, sometimes person get trapped in the greed. They say that your money will be doubled or it will be a very big, investment, you get lot of returns and person get trapped. Then fraud schemes, like in 3 years, your money will be multiplied to double or something like that. Then ransomware are on higher side. The very, very latest technologies are actually invading your data through ransomware. They silently sit in your device, maybe mobile phone or your computer, your laptop or whatever you are using, and silently, even if your device is shut down, then also your data, they are passing on to the desired target. or the controller. Deep fake, the biggest threat for your identity theft. Suppose you have submitted your Aadhaar card to bank. They take it and they utilize it for other purposes. As I earlier mentioned that sometime you submit your Aadhaar card, your identity credentials for taking a SIM. Generally, the service provider in India, they may provide 4 or 5 SIM also. If you see in Airtel, they have the scheme of providing 4 SIM on the same credentials in one customer portfolio. But you generally need only one, and you simply take out one SIM from the service provider's showroom, and afterwards the vendor may misutilize it, the rest 3 or 2 or 4, like that. So be very careful, and whenever you submit your identity document, the photocopy of it, please write that I am submitting this document for this purpose, maybe for bank, maybe for taking SIM, or whatever purpose you are, so that your document may be to some extent safe. Then national state crime espionage. In 2024, for example, the alleged Chinese sponsored attack targeting US telecommunication infrastructure. This is an allegation, and they exploited the vulnerability and used advanced persistent threat. So such type of threats are always being reported. Many comes to the newspapers and mainstream media, but sometimes the repercussions are so devastating that they may not come even to the news also. Then bullying and harassment. If you see digital arrest, they threat you. Likewise, they actually block your entire set of your system. They block it, and then they ask for big ransom. There are reported cases where the bank passwords, bank control system was completely ransacked, and then hefty money transacted, and then only they give back to the access to the data of bank. Or you might have heard recently about some phishing or some cyber crime in airlines and all. So these are critical infrastructure. So such type of attacks are really very, very important. Then let us see, if we want to enact the law, what are the challenges? The first is the uniformity. As I said, every jurisdiction has its own requirement. They have their own legal culture. So uniformity is missing across globe. Every country has its own set of legal regime on data protection. Of course, 60-70% content remains same, but 30-40%, especially the procedural part, is different. Then national security and personal privacy. That is again very sovereign issue. National security is the most sacrosanct duty of the state to maintain its sovereignty. Then personal privacy. These are the two issues, and they are conflicting sometime in the same country. That on one side we have to protect the public interest or national interest, which is larger. On contrary to that, you have the personal interest. Sometimes they may be clashing. Suppose for the purpose of larger personal national security, they may have to evaluate or to examine the data of mobile phone or your various other data from the single person, individual, or maybe a group of people. On the face of it, it may look like entering into the privacy of a person, or individual data may be compromised, or you can say maybe surveillanced, and personal privacy gets invaded. But here is the catch, that for the purpose of national security it is required. So there has to be a subtle balance between the national security or public interest and individual interest, right? Then this is a very, very interesting case of 2013 in June. Edward Snowden, he actually disclosed that US National Security Agency has undergone a very huge surveillance on the masses at some point of time. He disclosed that. And such type of surveillance is very, very common. Even sometimes common people may not be knowing. So the government has access to data, and there is a need to have a legal regime so that the data should not be misused for the purpose of surveillance in the name of national security. That's a very, very touchy subject, very, very critical subject, but this is the issue across the globe. Various people always crib, or they complain, they allege that their data get examined or surveillanced by their own country for various reasons, or some country allege to the another country that their critical data or that there are invasion, and now it is cyber warfare. So this area remains very, very critical and challenging. There are enforcement challenges. Suppose there is a report case of cyber crime. So for the purpose of enforcement, there are various challenges. For example, jurisdiction. Then the person may be sitting very, very far away. Then there are concealment of facts, layering. So it's not that easy that you just go, catch the person, recover the stolen property or something like that. The digital world is very, very critical. There are deep fake scenarios. There are, so many complexities involved therein. So now I just come to the point that suppose we have to build or to enact cyber protection laws or data protection laws. What should be the basic ingredient? So I have tried to narrate those basic skeleton or basic structure of Data Protection Act, which may be helpful to understand various nuances of the data protection laws across the globe. So first is its scope. The Data Protection Act may be either sectorial or federal. Sectorial, for example, I told you in US. US has federal for the entire nation, and their state has different data protection laws, right? So that is called sectorial, when there are various different segments of data protection laws. On the contrary, there are unified law like DPDP Act in India, like the Data Protection Act of 2018 in United Kingdom. If we see the key principle, which are the pillars of Data Protection Act, the one is lawfulness. You have to surveillance anybody's data only through legal means. So lawfulness is very, very important segment. Otherwise, in the name of national security, various governments are being alleged to intervene in the data of the individuals. Then it should be transparent. Whatever the system, the government are doing, or the individuals are doing, or the agencies who are actually protecting the data, what they are doing, it should be transparent. Suppose you have the bank account, and bankers are actually providing data to all people. And here I tell you one catch. You go to any shop, you provide your telephone number, your date of birth, your marriage anniversary, just thinking that you may get some SMS. Sometime they give you some gift, small gift and all. But they provide that data to other these service providers. Say for example Zomato or any other service provider. And you start getting lot of SMS. From where? The data they are getting. They are getting this data from those service provider where you have willingly submit. But you have not willingly told them to circulate that data to somebody else. And here is the data privacy violation. Then consent, as I said, that in that particular form when you filled up, suppose you went to a store and willingly you provide them your mobile number, your email address, your own home address, or maybe some other data. So you have given consent. But you have not consented to share that data with others. And all these companies, they are getting a lot of money for providing that data to other service providers. And this is basically violation of your data privacy. And here you can go for claim this breach of your right. Then cross-border data transfer, that is another problem, because in one country the laws may be different. Once the data is going, you are calling to US, UK, so data is flowing from one country to another, and there the rule of laws are different, so implementation becomes critical. Then regulatory body or enforcement authority, their power, their independence. This is again very important when you are planning to build or to enact law. So independence of the regulating body, because that regulating body is also hearing those cases or adjudicating those cases which are against the government. So these bodies are very, very important for implementation of these laws. So the regulating body should be having independence, at least functional independence, and better if they are statutory in nature. Then penalty for violation, how much penalty you will give or you will levy. We will see that the penalty are huge, although the data is also very, very valuable, as I said. So should be the penalty quantum also. Then right of data principle. I will use this word data principle frequently now onwards. Data principle means the person who is the holder of the data or who is the owner of the data. Suppose it is your mobile phone or it is your bank account. So you are the data principal for that particular data. So remember this word, data principal means owner of the data. And duties and safeguard for fiduciary. Fiduciary means the person who is actually custodian. Suppose I have a bank account in a particular bank, maybe Axis, State Bank or whatever. So for me, I am the data principal and the bank is fiduciary. So there should be a critical or clear relationship between data principal and fiduciary. And this is actually matter of conflict. Then appellate mechanism. So as I said that there is a regulatory body, but the judgment by the regulatory body, there should be an appellate authority also. So there are at least two tiers. One is the regulating authority, which actually adjudicate the dispute, and above that, that particular order may be appellated by some other higher authority or other body. So this is the basic structure of your Data Protection Act. Whenever you are studying any act, important judgment, that is Justice K.S. Puttaswamy versus Union of India. I repeat, Justice K.S. Puttaswamy, who was a retired judge, versus Union of India. This judgment was decided by Honorable Supreme Court in year 17. एक कोई सुनता रहे फिर वहां. So friends, sorry, there was some interruption of internet. So I will repeat few things which probably you could miss to hear. So we were talking about the right to privacy. My dear friends, in data protection, right to privacy is a very, very important right of an individual. Okay? So you must know that right to privacy in the recent past in India has been made integral part of right to life, and it has been made fundamental right, because fundamental right is fundamental since it is very important for developing the personality of an individual. That is why these rights are very, very important. On the contrary to fundamental right, the others right are called legal right. What is the difference between fundamental right and legal right? Dear friends, for the purpose of their implementation, in case of legal right, you have to go either to police or to another executive authority, or maybe in case of civil matters for the civil court. But in case of fundamental right, under the writ jurisdiction of the Constitutional Court, you can directly go to Supreme Court or the concerned High Court. For the purpose of knocking the door of Honorable Supreme Court, you have to utilize Article 32, meaning thereby under Article 32 of the Indian Constitution, the writ jurisdiction applies for the Supreme Court. There are 5 writs. We will talk sometime later in detail what are these 5 writs. If you want to go for the concerned High Court, then Article 226 enable you for utilizing either of the 5 writs. So fundamental right is very, enabling legal tool for enforcing or securing your basic rights, the rights which are very important for growth of the person. Interestingly, in India, in year 2017, one case was filed which was decided by Honorable Supreme Court by 9-judge bench. The case is Justice K.S. Puttaswamy, the retired High Court judge, versus Union of India. In this case, the privacy right was first time made fundamental right. And this right, as you said, has transformed the entire gambit of right domain for privacy. Just after 1 year, in 2018, another case by the same petitioner, Justice K.S. Puttaswamy, the retired High Court judge versus Union of India, was decided by 5-judge bench, and this is called Aadhaar case. In Aadhaar case, the issue was whether the information shared by an individual or the Aadhaar holder can be shared by other agency. The court reply is negative. They said no. And not only Aadhaar information, but DNA and various other data bank information were also covered under right to privacy as fundamental right. So these 2 judgments are very, very important for data privacy and data protection, and that has been taken into account in DPDP Act 2023 in a very big way. Before entering into further domain of DPDP Act 2022, let us see how the crime in cyberspace, that is called cyber crime, how they are growing in India. So this is the statistics I have taken from National Crime Record Bureau in last 3 years, 2023, 2020, 2021 and 2022, because this is the last report till date, and there is an increase of about 4.8%. I believe as a police officer that this growth is much higher, but probably the people are either not knowing that they are victimized by the cyber criminals, or they do not go to the police, or sometimes police may not be directly registering the case. But here I want to make you aware that suppose in case you get victimized of cyber crime, please use helpline number 1930. Again I repeat, helpline free of cost, the number is 1930, and then you can give information about cyber crime if you get victimized at any point of time. So cyber crime with sexual exploitation overtone under section 67 of IT Act 2020. These cases have also been reported. The number is 6896. So these are related to sextortion type of cases which we mentioned earlier. Now, this is DPDP Act. So first of all, understand what DPDP stands for. It is basically Digital Personal Data Protection. Digital Personal Data Protection Act 2023. The number is, generally every act has its number. Its number is 22 of 2023. So DPDP Act 2023, let us understand few definition. So definition clause in this act is section 2. So section 2 subsection H talk about data. So understand what is data. It is a very elaborative definition of data. Data means a representation of information, fact, concept, opinion or instruction in a manner suitable for communication, interpretation or processing by human being or by automated means. That means it may be a communication, it may be a concept, it may be an opinion, it may be instruction which may be given by a human being or by any means or non-human being machines or something like that. So data has been defined in a much wider horizon. Then another important definition is what is personal data. We have defined data in 2 subsection H and sections 2 subsection T talk about personal data. What is personal data? Personal data means any data about an individual who is identifiable by or in relation to such data. That means that you put the definition given in data for a person and then you will apply section 2T of DPDP Act. If you see the chapters, there are total chapters are 9. It has total sections 44, that is 44, and it has one schedule. This schedule actually has 7 breaches. Breaches means the list that which they identify or they recognize as breach. This is very, very important schedule, and every breach has corresponding penalties. And in Indian DPDP Act, for these breaches, for single breach, the penalty is to the tune of rupees 250 crores. Just imagine that depending upon the importance of data, the data breach may result into slapping rupees 250 crores on the violating person, individual, company, corporation or anybody whosoever is the fiduciary. Now, salient feature if we talk about DPDP Act. The scope, it has all over India jurisdiction. That is one. Then it also applies for data of an Indian processed outside India. Suppose we are in India, but our data is processed outside India. There may be data storage somewhere outside, right? Or somewhere the data is processed. Suppose we are taking some services outside our country. So that area where the data is processed, that is also covered by DP Act. So you cannot take away, or the fiduciary cannot take away or cannot be escape thinking that he is not residing in India. Rights of data principle, that means I told you the owner of the data, what are their rights? Right to information, how and for purpose the data is processed. So suppose if I share my data to bank or to the telephone industry service provider, so I have the right as data principal to know that how those information which I shared with them, they've been processed, right? I have the right to correct the data. I have the right to modify the data. I have the right to delete the data if it is obsolete or it has no value. In case of any grievance, I have the redressal mechanism, and the redressal mechanism in India, which is very, very important and one must know about, is the Data Protection Board. So regulating body for grievance purpose to address the grievance is Data Protection Board. Then let us see about the obligation of data fiduciary. On the other side, I said one side is the data principal, other side is the data fiduciary, who is actually custodian of that data on behalf of the data principal. So they have the limitation of purpose. If suppose I gave it for issuing my Aadhaar card, they cannot share it with any other one. So there is a limitation of data. Suppose I submit my personal information about my date of birth, about my residence, about my mobile, about my email to get a SIM. So that is a limitation of the purpose. They cannot utilize that data for other purpose. Then usage of data only for a specified purpose, as I said. Then the consent. What purpose I have consented. So I must know the purpose, what purpose they will be utilizing it. And that information or the consent must be looked from two angles. It should be informed consent, and I should be the person who is data principal should be competent to give consent. And for this purpose, DPDP Act, the age for consent is 12 years. Normally age of consent is 18 years, but here it is kept for certain purpose 12 years. Then data security measures. The data fiduciary has this obligation that my data as a data principal, they should keep it with sufficient data protection measures. There should be data security. It should not be as if it is open to all. Anybody can steal my data if I have given for bank or any other fiduciary. So it is the responsibility of the fiduciary to protect, to have proper measures of cyber security. Then in case there is any breach of the data on the side of the data fiduciary, the data fiduciary is duty bound to inform timely to the data principal about that breach, that somebody has stolen. Suppose there is something phishing in my bank account and somebody cheated, right? My bank account got hacked, or suppose my mobile phone got hacked, or my Facebook got hacked. So it is the duty of the fiduciary to inform timely. Secondly, they should have proper measure to counter the loss or damage control or mitigating the damage. So these are certain important area to look at. Now, moving ahead, if we see what is the consent framework in our DPDP Act, it is informed consent. In DPDP Act, we have taken the measures of informed consent. In what manner? We have to take the consent which is free in nature. There is no compulsion. It should be specific what purpose the consent has been given. It should be informed. The person may not be very well educated. So it is the duty of fiduciary to inform that what purpose this information or this data will be shared or will be utilized. Then if there is any ambiguity, it should be cleared. Then there may be sometime deemed consent. It is important to understand. In certain situations, suppose there is any medical emergency. So for saving lives or maybe saving damage for larger public interest. So then there may not be time to take implicit consent, right, or direct consent. Then it is called deemed consent in that manner. Then data localization. The data localization is also incorporated in our Act, DPDP Act. Cross-border data transfer is allowed if permitted by the Government of India. That means data transfer is governed by data fiduciary in consonance with the rules and regulation framed by Government of India. So data localization is directly related to the policy made by our federal government or the Government of India. Then penalty. As I told that for every breach, there is a amount as penalty. The highest penalty is rupees 250 crores for each breach. So this is the magnitude. Then grievance redressal mechanism by Data Protection Board. As I said, it is a unified body and it is a very powerful body we have. Now, DPDP Act, more points. There are certain exemptions for the government. As I told, these exemptions are only related for the national security. So these are the exemptions. Government exempt under section 17 of DPDP Act, and they actually can use your data without your consent for the purpose of national security. Suppose somebody is suspected to indulge into anti-national activity, then your data without your consent can be surveillanced, can be explored, can be utilized, can be analyzed. Then public order data. If there is a question of public order, then your data may be utilized. Say for example, there is a terror event and it is on a very big platform. Then the CCTV footage may be screened for the purpose of tracing the culprit. Then prevention of fraud. Suppose there are possibility of a larger fraud, then your data may be explored by the government. Then in investigation and prosecution purpose, your data, suppose you are indulged or you are allegedly indulged in any crime, then your mobile phone, your laptop, your desktop or any other device may be seized, it can be explored. But here again, if there is anything which is not related to crime and you claim that this is the privacy domain, there may be in the same laptop or same device, there may be some files related to that crime, but may not necessarily all the data, maybe my personal file, my family members or some other. So you have to claim that this is the privacy content, and suppose if investigator has some doubt, then it may be, contested before the court, and then court can decide whether those files should be opened or not. However, the problem also with these measures or these exemptions, the criticism are wide discretions. DPDP Act has wide discretions. It is considered or it is said that it is more favoring the government and their surveillance rights and other things are very wide, it is being alleged. Then it is potentially overreach, lack of judicial oversight. Then transparency issues are also being flagged by some, analysts or legal review experts. Then limited accountability. For the breaches, it is still said that the accountability is limited. So I thought appropriate to tell you a little bit more about Data Protection Board. What about this? DPB is the central regulating authority for adjudicating the grievances of the data principle to safeguard the data, and if there is any breach, then can decide the dispute. It is an independent body having power of a civil court. What do you mean by a civil court? Civil court means that has the power to summon you, to call any paper, any document, to give orders to someone to be present in the court. And it impose penalty up to rupees 250, as I told you in DPDP Act the penalty. Then appellate authority, there are two appellate authority. The first appellate authority is the higher authority than DPB. An order of DPB may be challenged before the Telecom Dispute Settlement and Appellate Tribunal. This is the name of the first authority for appeal, Telecom Dispute Settlement and Appellate Tribunal. Then final appeal is before Honorable Supreme Court. So that final appeal can be finalized or can be lodged before Honorable Supreme Court of India. Now, after DPDP Act 2023, recently in December 2024, Government of India has formulated DPDP Rule 2024. So just few important points, let us have a look. It provides detailed guideline for implementation of the Act 2023. It basically deals about or give a detailed description how cross-border data can be transferred. It also has the rules for compliance and obligations, and in case of data breach, how those breaches should be notified. So that is also clearly been specified. Then there are certain special provision for children's data, parents' consent, and additional safeguard are in place. So these are certain, critical features of DPDP Act and DPDP rules. Probably, I believe that you might have been benefited with discussion as far as India is concerned. Now, let me talk about United Kingdom, and before that, we will be talking about European Union. You are aware that UK is also part of European Union, and majority of European Union countries, they actually follow GDPR, European Union Data Protection Regulations. European Union Data Protection Regulation, by and large, various issues are similar to what we have discussed in the general framework of any Data Protection Act. So, same here, the territorial scope. These GDPR, it was operational from 25th May of 2018, and it is applicable within the countries of European Union. It covers offering of service and goods or monitoring their behavior. The personal data protection, as I said, like in India, the definition has so many commonalities. Any information that can identify individual directly or indirectly by its name, address, email, IP address, sensitive data like race, origin, political opinion, sexual orientation and all, right? This much detail was not there in DPDP Act, but it has given a wider umbrella for the data actually which is being personal in nature and has so many individuals' information. Then right of the data subject. Here it is called data subject, which we call data principal. So data subject and data principal are the same, meaning thereby data subject or data principals are the owner of the data, and obligation of data fiduciary and lawful basis for data processing. So these are the common areas which already we have discussed. So similar things were being placed in European Union data protection regulations. The general data protection regulations, actually it has also consent management, it has detailed consent management, data breach notification, as I said in DPDP Act, that if there is a breach in data protection, then you have to notify and inform the data principal. Then appointment of data protection officer. Here in our case we called it board and they called it officer. So data protection officers they have, we have data protection board. Then accountability and compliances. Then cross-border data transfer. Cross-border data transfer is already discussed. So we have discussed so far the laws in India, then in European Union, and now let us see what are the laws, special laws in UK. So they follow UK General Data Protection Regulation, GDPR, and Data Protection Act 2018. This is wrongly written. It is actually Data Protection the Data Protection Act DPA 2018. So it is by mistake written. Read it, 2018. The General Data Protection Regulation GDPR, actually they apply on entire UK. It is not like sectorial in US, it is the federal in nature. Entire country is being covered by these general GDPR, then aligned with the European Union. So they have their own GDPR, some modifications. The key principles, like in India, lawfulness, fairness, transparency, purpose limitation, data minimization, accuracy of data, storage, limitation, integrity and confidentiality. So you must have heard that what we have studied in the beginning, that what should be the ingredient, by and large, they are being followed across the different jurisdictions, including India. These are the key principles of UK GDPR. Right to access, it is with the data principle. Then right to rectification, if you want to rectify your data as data principal or data subject, then you have the right. Then right to erase, if you want to erase the data, you can. Then right to restrict processing, if you want to restrict the process of your data, you can write to the data fiduciary to do so. Right to data portability, if you want to port your SIM card or any other bank or another data, nobody is going to stop you. So that is data portability. Right to object, if you have some objection, you can do that. That is your right. Then data breach notification, as I mentioned, that suppose, first of all, the fiduciary is obligated to have proper measures of cyber security so that your data should be protected. But in case there is any violation or there is any breach, then data fiduciary is duty bound to inform timely to data principal and also to take mitigating measures immediately so that there should be, the harm should be as minimum as possible. Then penalty, here the penalty is even much higher. It is up to 17.5 million pounds. So I think it amounts to a huge quantum of money. Yes. So I was talking about the regulations of 2018. Now this is UK Data Protection Act DPA 2018. The exemption it also contain like in Indian DPDP Act, national security and intelligence, they are exempted for this purpose. The special category of data, sensitive data like race, opinion, health, sexual orientation, they cannot be exempted. Special provision for law enforcement, for data processing, for crime prevention, detection and prosecution. These are the same as we have in our DPDP Act. Then the exemption for this is the journalism, the academia and public interest. The supervisory authority here is the Information Commissioner Office. So they are the supervisory officers like we have DP Board, Data Protection Board. The European Union has Data Protection Officer and they have Information Commissioner Office, right? With power to investigate, issue fines, and they have also civil court jurisdiction like. Now let us have some comparative metrics. I have selectively not touched about US because they have similar type of sectorial system. They have different state rules, state act. So I thought that these are the similar activities. So not to stretch further, I have made a comparative chart where US has also been taken into account in a comparative manner. And this is my forte, my dear friends, that I always give you in a single table a comparative matrix so that you can understand the nuances in a single sheet. So here, these are the aspect laws. The name in European Union is GDPR 2018. In United Kingdom, it is UK GDPR and Data Protection Act 2018. In United States, they are in the different states, the name are different. And in India, DPDP Act 2023. Then scope, it covers all identity in European Union. The UK GDPR and DPA, they are in the entire country. In United States, as I said, it is state-wise. And in India, the DPDP Act is for the entire country. The consent should be explicit. I think it is by and large similar in all the countries. Then cross-border transfer, that is also permitted to country having adequate safeguard. This is important. They permit to country having adequate safeguard. There is no restriction in United States for this purpose. And likewise in India, we follow European Union model. So we only permit to those countries where we have similar data protection standards. Then enforcement authority, as I told you, in European Union it is DPA. Here also it is DPA, means that is authority name. It may be officer, it may be different, but we have Data Protection Board. Then penalty, here it is up to 20 million. Likewise in United Kingdom it is up to very high quantum. Then in United States it varies. And in India, it is up to 250 crores. Data subject right. Data subject means data principal. They have access to data rectification, erasure and all. These are similar in all the areas. And emerging technology. The European Union laws, they apply to AI and IoTs. Similarly in United Kingdom also. However, in US, it varies from state to state. In our country, we apply DPDP Act to digital technology, but we do not have any specific mention of AI, right? So I hope that you could get some understanding of data protection legal regime in India and across. So with this, I think we could cover this very important topic for data protection nearly in 1 hour. I place on record my apology that there was some disruption or interruption because of some technical glitch of internet, but I know you have so much love and affection, your support to me. So please be with us to spread knowledge, and very soon we will come with a new topic which will again enhance our knowledge of some importance in India and abroad. So thank you very much once again. Bye.